Honorable members and colleagues, good morning. Shall we? No, we're gonna fire questions. We're gonna fire questions. You know, I'm so not used to seeing members on this side. But you know what? For fun, let's get them to account anyway. Everybody who's sitting on this side. We had the National Lotteries Commission here, and we were complaining about DAs, if you remember. Yeah, so the DA is sitting on this side, so we can finally ask them to for the mess at the National Lotteries Commission. Honorable members, good morning, and thank you very much for being here. I'm hoping that today, us being on our own, largely will, let me say, members will have enough time to prepare for the House sitting during the afternoon. I am just concerned that there's a few honorable members who are here, and I think we just need to, Honorable Skosana was here and Honorable Madlala, so can we just get them in, please, yeah? The other Honorable Skosana. Anyway, what you missed is that the colleagues from the Democratic Alliance are accounting today. So, yeah, so you can direct any and all questions towards them. Honorable members, good morning, and thank you very much for making time. So I was saying that I'm hoping that today the members will have enough time to prepare for the afternoon session, if you know what I mean, because it's just the committee in discussion today. So on today's agenda, we have got two matters broadly, but three more specifically. The first is the Road Accident Fund. I have shared with the members a memo, which I will talk to at some detail. Secondly, we are going to approve the oversight reports. We're going to review the oversight reports and then take any proposed amendments and then finalize. In the case of the oversight reports, what we will do is we will take the comments of the members, and then once those have been effected, we will once more share them with the members and give about 2 days or so for everyone to review and be happy that the version that goes to the House is a version that everybody has seen. We've learned some lessons from the budget process. So we have to make sure that everybody gets to specifically say that they are happy with the content and there are no issues when we get there. So, sorry. Honorable Skosan.
Thank you, Chair. And good morning to all the colleagues and staff members. I just wanted to find out, because normally we have people here who we don't know. So when it comes to staff members, people who are sitting at our back, who are they? Because I know some of them, I don't know them. Thank you, Chair.
So we have the usual staff members, Honorable Skosana, that I am hoping that you know them. What typically happens in committee meetings, you also have members from the Parliament Monitoring Group. And those are the people that take detailed notes of the meetings and so on, and then they post them on for the public to see. And then all committee meetings are also open to the public, and members of the public can come and sit. We do not ask members of the public to introduce themselves because they are not participating in the proceedings.
My follow-up question, Chair. You know why I'm asking that? In one of the meetings in this core committee, when we were out there, some of these people who are sitting here, some of them, I'm not saying, I'm not casting aspersion in anyone. They approach us and say, why are we too radical in our questions? Hence, I'm asking that. To say that when we're talking about the issue of ref here, two gentlemen approached me here and say, but why are you saying people should have a friendly, lawyers must be the one who are dealing with this issue? And I was very offended, Chair. Hence, I'm asking. It's a deliberate question.
Yeah.
And please, Chair, only
My hand was up first, Chair, so I don't know why he's getting a second speaking opportunity.
No, it's a follow-up question. The Chair will answer. I don't need to.
Colleagues, can we? Colleagues,
try to be defensive. The Chair is here to chair the meeting.
Honourable Skosana, we are too early in the meeting.
Thank you.
And Honourable Beck, please. So I've heard you have taken your point. I'm now going to take the comment from Honourable Beck, and then I will make a final determination and we move.
Chair, it's I'm sorry that the colleague was offended that people approach him, but I'm afraid to inform him that we are all public representatives and you might very well be approached. This is an open meeting, it's not a closed meeting. The question is entirely inappropriate as to who's sitting in the back. Whoever wants to sit in the back, who's been given access to Parliament, can sit in the back. Let's proceed with the meeting.
Okay. Colleagues, can I just make a final determination on this? Okay. We have in the room honorable members of the committee. We have in the room the members of the secretariat. We all know them, they need no introduction. From time to time, in fact, almost at all meetings, we have people from the Parliament Monitoring Group. They work with Parliament. They perform an important public service. We have never asked them to introduce themselves, and those people change from time to time. We also have in the meetings representatives of members of the executive who are here to take notes on their behalf because the proceedings pertain to a particular department. For instance, I have come to know some of them. We never ask them to introduce themselves. Everyone else, I assume they're either members of the public, they are an interested party, they are a journalist, they are a member of an NPO or whatever the case is. We never ask them to introduce themselves. They sit in the meeting and the meeting proceeds. If, Honourable Skosana, there is someone who you believe has said something that is inappropriate, either in the proceedings or outside of the proceedings, that would need us to raise it with Parliament, in that they've threatened someone or that sort of thing, that we can take up. But what we cannot start doing is asking members of the public and other interested parties to introduce themselves. Parliament has never done that. So can we please move on? Unless there is something that you are feeling threatened, you cannot proceed with the meeting because of that, then sure. But otherwise, I don't see why we need to do that. Honourable Madlal.
Thank you, Chair. I concur with you that we need to proceed. I think as a matter of principle, though, what we may want to address going forward is the accreditation process. We understand that there's a process of Parliament. It's a public meeting, but I don't know. I've got my member of Parliament card. I'm known who I'm. I don't think that we need to have people introducing themselves, per se. But in future, we can't, as a committee, have people without tags. And let's say maybe they become 30. Who controls that? I'm trying to understand. Now there is a discussion. It needs to be controlled. in a manner that everyone is comforted to say, okay, this is media, they've got a tech, they've got access, this is so and so. They don't need to introduce themselves. So our members of parliament who are known, this is where we sit. Everyone knows who we are. They don't even need to ask us. I'm thinking that there may be some clarity needed along those lines. Thank you.
Thank you, Honourable Madlala. So the process is, and I've been a visitor to Parliament numerous times, and I've also seen this process works. There is a visitors centre, which is the other entrance, which is on the side of Good Hope Centre. Everybody that comes into the precinct, whether they're going to an office or they're going to a meeting, presents themselves there, they are searched, they say why they're here, and they are given a pass. The pass they get, unfortunately, does not have a lanyard. It's a piece of paper. When they get to the bottom where we swipe, they present this pass and they once again scan their belongings, as we all do when we enter the meeting. My belief is anybody who makes it up to this point has gone through that process. That is what government officials have to do. That's what everybody who comes to the committee has to do. If your suggestion is that we say to Parliament everybody should then get a lanyard, we can have that conversation with Parliament facilities, but there are two checkpoints. Nobody can enter this building unless they are a member, they work in Parliament, or they've been given a pass by security, and downstairs they've got to produce it. Once we are here, my assumption is all of those protocols have been enforced, and so I don't know if then we must ask people once again to create another security checkpoint. I don't think it's appropriate for the committee to do that, but that's the process. So everybody who's here has stated their business, why they're here. So can we, members, can we proceed? I honestly, can we please proceed, members? Please. What's important is that to the extent that there is, I haven't experienced anyone, the only time there was a disruption here is when new members of the PMG group walked behind me right here, and it was their first time and they were very apologetic. Beyond that, we have not had a disruption in the meeting. So please, members, can we please proceed with the meeting? I don't want us to get distracted by an ancillary issue like this, please.
Because I started this thing myself, and for a reason. And for me, no one is going to intimidate me. We can start the meeting, but what I don't like, if someone comes in because he doesn't know or he wants to protect someone he doesn't know about. I'm saying about my experience here. I'm talking about my experience. It doesn't matter whether they can come 100 of them here, but I'm saying they must stop. When we are out of this meeting to discuss issues which we discuss it here, because this where we are.
Because you are not going to keep speaking when we are speaking. You say, Chair, we do have the capacity.
Colleagues, no,
we
colleagues.
do have the capacity to be arrogant. We won't tolerate
colleagues.
We won't tolerate him, Chair.
Colleagues, can I?
This young boy thinks he's going to speak anytime he wants when we are speaking.
Parliament won't do
Honorable Beck, Honorable Skosan, colleagues, please, can you please switch off your mics, please?
Yes. Yeah, we are racist, yes.
No, colleagues, can you please switch off your mics, please, members. Members, we can spend the next hour debating ancillary issues, or we can get on with the business of the meeting. Can I appeal to you? The reason I said once I speak we're going to proceed in this way is because I know this meeting we can spend the next hour or so now discussing ancillary issues, okay? The only thing I'm going to ask members is that we respect one another. When another member has the floor, we allow that member to finish speaking, however strongly we feel about what they're saying. Yes. And Honorable Beck, I have to say that you have spoken over a member while they're speaking.
Chair, he called me a racist. He pointed his finger at me. You're addressing me.
So colleagues, come on. Colleagues, we have to make a decision here, okay? So we have to make a decision here about proposing. Okay, so Honorable Skosana, may I also say to you, because this is going to take us down a rabbit hole of what is parliamentary to say and what is not. Let us not get into that territory. May I please, you might feel strongly about Honorable Beck's behavior, but when you say he is being racist, it takes us down that rabbit hole. May I please ask you to withdraw that specific comment?
No, I'm not going to.
So,
I'm not going to. He said it himself as well.
what did he say?
I said I'm a racist.
That's what he said, yes.
Okay.
Okay, may I then propose that if Honorable Beck wants to take the matter up in terms of the rules? No, sure, I am chairing the committee. No, hang on. I'm going to come to you, Honorable Ment and Honorable Beasley, okay, and Honorable Skosana. I'm going to come to you. But all I'm saying is that I expect when we get here as members to focus on the business at hand, to recognize that we've got differences over various issues, but the most important thing is maintaining the decorum of the meeting. We don't interrupt each other, we don't call each other names. That's very important. And the reason I am saying, I was suggesting to Honorable Skosana, and I can't force you to do it, that you withdraw that comment, is so that we can move on. There are no mutual complaints that go up the rules and up the chain, and we've got to make rulings, because I would like us to proceed with the meeting and our proceedings in terms of the way that we have before. I'm not protecting anyone. But what can happen in this meeting is that we can then spend the next hour or two discussing technicalities and who said what to whom and so on, and I don't think that is appropriate given the importance of the issues at hand. Can't prevent you from speaking, so I'm suggesting that we please move on. But if members feel that you need to still make your comments, then let me know. But can we please proceed? So Honorable Mentor, you had your hand up, then it was Honorable Beasley, then it was Honorable Skosan.
Thank you, Chair. Good morning. Chair, you know, a problem starts when a member has valid reasons to say whatever they want to say and to raise any concerns they have. But what cannot be happening and what cannot be allowed is another member invalidating the concerns of another member. Honorable Skosana raised his consent. You addressed the concerns and you paved the way forward. Member of the DA takes the mic, invalidates that which you have already ruled on, and the feelings and concerns of Skosana as well, which is wrong. That's why you should have called him, I'm done with this matter. There's no need for you to speak, because he felt that he's too important. He must do it even when you have done it. That is why we are going to have a degeneration, because there's no member that can come here and be invalidated by another member. And that's not going to happen, and we're not going to allow it. So please, Chair, when a member has spoken and you have paved the way forward about that, it ends there. No other member must feel very important that they must say anything besides that. We want to keep quiet. Every time you say, members, I'm pleading with you, let's no longer say anything. We all kept quiet. But he kept on coming. And you don't say to him, please stop. He must stop doing that. He must stop invalidating us. He's not important in this meeting more than anyone else. Thank you.
Thank you, Honorable Beasley.
Yeah, thanks, Chair. I just think what I saw transpired is it's very disappointing, and I think we just need to show respect towards each other. We're human beings. We might disagree with each other, but let's respect each other. We've been voted here by certain constituencies. By insulting the other people, we're insulting their constituencies. So let's just treat people with respect. I was taught manners growing up, and I think some people in this room need to learn manners, and it's just a matter of common courtesy and common respect. And I'll put that forward. And South Africans deserve better than what's just transpired. We're better than this. We're here to lead this country, not to further divide it. Thank you, Chair.
Thank you, Honorable Beasley. Honorable Skosan.
Yeah, no, thank you very much, Honorable Chair. Yeah, Chair, I think you handled the concern that was raised earlier by Honorable Skosana very well in terms of the processes and procedures of Parliament. And we commend you for that. Yeah, well, I think Honorable Beck, I think he's got a weakness. I think this thing is a weakness because he's not doing it for the second time, that when he's not happy with something, he would just come in. So it's a very serious weakness that he need to work on it. I think it was uncalled for him to do that. But also, I think it's also wrong and unparliamentary for Honorable Skosana to call him a racist. In terms of Rule 84, that's an unparliamentary language. You can call the DA as an organization a racist organization. That will be a point of debate. And that will be his views. But to call a specific member a racist, that is unparliamentary. Thanks, Chair.
Okay, members, I think Honorable Beasley and Honorable Skosana and Honorable Mende have brought us to the close of the issue, please, okay? Let us recognize what they've said. Let us recognize what they said and accept that we are going to treat one another with the necessary decorum and respect for the people that are watching this meeting from home. May I please ask colleagues, however much we feel about what a member might be saying and however much we disagree, we leave that member to have the floor until they are done. There is enough time and too few of us here today to worry about not getting a chance to speak. We are all going to get a chance to speak, members. Please, thank you so much. I really appreciate your cooperation. Members, thank you. So shall we go back to the issues on the agenda? So the first one is a matter of the Road Accident Fund. And I'm going to preface my comments in this way. And we've distributed the memo to the members, but I have nonetheless asked the committee secretariat to put it up. And I'm going to preface my comments in this way. The committee generally gets any number of whistleblower and public concerns about honorable members and colleagues, please. WhatsApp each other. We get a number of concerns, whistleblowings and so on, and we, at least I feel an obligation to follow up on all of them if we can. There is an anomaly in that reality that we deal with. The volume of communication, either from members of the public, the staff, or other stakeholders of the Road Accident Fund, is I can only term as a flood. I have had to ask that we rearrange the way the committee secretariat works so that we may have somebody who just helps us with those matters. They are too many. They are too concerning. They come at such a frequency that even this memo that we are presenting, when I consider what we received on Thursday, Friday, the weekend, and this morning, it is already becoming obsolete. That is the volume of concerns that we get. Now, the committee has a vast amount of work that it has to do. We still need to complete our conversation with Dinel. There are new issues that have emerged at PRASA, for an example, etc., etc. I can't go through the whole list, but our work is voluminous. We can't have the same institution coming here every month to the detriment of oversight on other institutions. So I'm going to put it up front so the members know where I am going with this. We will need to collect as much of this information at a certain point, compile it, synthesize it, make it available to the members, and then we have a committee inquiry where we set aside a specific amount of time, we deal with the issues, we compile a report with recommendations for the executive, for parliament, etc., and we know that we've dealt with the issues. Otherwise, we're going to have the Road Accident Fund going up and down to parliament all the time to deal with things that we get, and I don't think that is an efficient use of our time. So that is the first thing. The second thing I want to say is that there are so many points of dispute, and people that are able to come to Parliament, who was here when something happened, who was not here when something happened, and particular instances, several instances where I have felt and have raised in the committee that the level of disclosure and the truthfulness of the information is lacking. So one of the things an inquiry will assist us is that we will then be able, if necessary, to subpoena people, whether they're still with the institution or not, whether they're still with the government or not, to come and present themselves and account to the committee, to Parliament, and to South Africans in general, so that we can get to the bottom of what the issues are at the Road Accident Fund. So that is the second thing that I think is important. That's where I'm going with this. And part of what we need to do, at least at a high level, is to agree, in the event that we agree to part one, is to agree what then would be the terms of reference and the scope. The third thing that I want to say is that the mandate of our committee is specific. We are not the portfolio committee on transport, under which the Road Accident Fund falls. But we are tasked with ensuring accountability in terms of what we believe is maladministration, financial mismanagement, misallocation or use of public resources, and so on. And the matters that I have placed before the committee in this memorandum, in the end, lead to all of that, to all of those. The seeds of maladministration, actual maladministration, the inappropriate use of public funds, etc., or waste. Because the members have the memorandum before them, I am not going to read it. I am, however, as the person and I'm grateful for the help that I received from the committee secretariat in pulling this together, ultimately it's my signature on it, and I must own it and explain the memorandum to everyone. And do this recognizing that there continues to be much public debate and appearance in other portfolio committees. The first thing that I've placed before the committee in the memo is my interpretation and implication of the organogram and the vacancies, and therefore the lines of authority that arise as a result, and therefore the impact that it has on public funds as a consequence. And I've made several examples, and I will not do this in sequence. For example, the committee has raised previously the issue of people who are facing disciplinary charges in one place, go to another institution, get a job, and life continues as usual. The committee has continually asked about the vetting of officials. In almost every meeting, the committee asks. You have all been here when we've asked the Road Accident Fund about the vetting of officials in general, and also the vetting of particular individuals. And we've received conflicting reports. On the 26th or 16th or 19th of October in 2024, we were here, the chief executive of the Road Accident Fund and the chairperson, they were sitting on this side. They said the chief executive has been vetted. They came here in March this year. They said the chief executive has not been vetted. They forgot what they told us in October. That's an anomaly. The second instance, we had a back and forth about the role of chief investment officer. I have explained in the memo that, first of all, the Road Accident Fund is not the PIC. Chief investment officers do long-term asset allocation or capital allocation. That's not the role of the Road Accident Fund. It so happens that the person who's acting in that role is a person who falls under a concern the committee has raised about the vetting of people and people escaping discipline. Members were here in March when I asked, where is this money invested? The chief executive of the Road Accident Fund said, we can't tell you where the money is invested because there are people who are looking for it. If the PIC were to appear here and say to the members, we can't tell you where the money is, I think justifiably the members would be outraged. But that answer was given to this committee. So incidents like that make anyone ask, hang on, what is really going on here? Why are we getting these answers and so on? I will make 2 further points on this organogram. There is no chief claims officer. There is no head of claims operations, as we can see. The people in the regions, according to some of the whistleblower accounts we have, are acting. So the entire claims ecosystem is gutted. Then there is no head of legal. There hasn't been a head of legal for 2.5 years. In fact, by the Road Accident Fund's own letter to me on Friday, they last advertised for that role and the chief claims officer in 2023. They did nothing for the rest of the second half of 2023 and nothing in 2024 and nothing for the first half of 2025. That cannot be correct. That has got a serious impact because the Road Accident Fund works with litigation which in the end costs taxpayers money. Over and above that, within a short period of time, I've said in the committee, that's what I mean by obsolete. I asked the Road Accident Fund, how many legal staff have you lost over the last 3 years? They've lost 28. And there's no head of legal. And the Road Accident Fund is not even able to show up in court to say we are defending a matter. And where someone should be awarded 500,000 rand, they might get away with 6 million. Because there's no one to defend the matter. And when the Road Accident Fund shows up to now try and overturn, the court says, you should have been here, you were not here, you are still not ready. Punitive costs over and above, which taxpayers pay. I'm going to leave it here because I'll be repeating the memo. All I'm saying is that when you objectively look at the organogram, and you look at the vacancies and the financial impact, you come to the conclusion that someone must account for this state of affairs. It cannot be okay because we have to be consistent as a committee. If we ask other institutions these questions about acting people and the impact, we have to ask everyone about these matters. So that is the first thing and the issues that attend to it. Denzel, can we move on to the second topic then? We were here as members of the committee, and I've dealt with all of those issues, Denzel. So we were here as members of the committee the other time. We've dealt with the inaccurate and false information and just not being given information. I will make just 2 examples here. We had to adjourn this committee meeting to obtain information that we had asked for as long ago as the 16th of November last year, about law firms that the Road Accident Fund pays to handle its matters. They didn't give it to us. I said in October they don't have it. I sent a letter on the 16th of November, asked for it. They didn't give it. We invited them to provide it in March. They didn't provide it. They then came back again in May. And then eventually we said, please do it now. In that disclosure, there were 2 overall material omissions. The first is the total amount that is given, that is paid to the law firms. It was inaccurate in 2 respects. One, how much has been allocated and paid to some of those law firms. There were also law firms that were not even on the list, like Mashiane Moodley. They were not even on the list, but they were paid by the Road Accident Fund. That introduces a difficulty for the committee in that we are now not certain about the quality and truthfulness of the information that is provided to the committee. So can we move on to the next one? So let's move to the next topic. Then there are further allegations about some of the contracts that the Road Accident Fund has. And one of the things I do, members, is that when somebody makes an allegation, I do write to the institution to ask for their view and evidence thereof. I can tell you those 2 media services contracts exist. The members will get them. They exist. They arrived on Friday evening. I just didn't have enough time to synthesize everything. They are signed by an executive who is not of that function that should sign them, because that person is acting. The signatures do not look the same. even though they're signatures of the same person. The deliverables are unclear. And I'm speaking as somebody who's concluded similar contracts in the past in my professional career. They are supposed to last 5 years. The rate of expenditure is such that one of those is nearly depleted already, but it's got 2 more years to run. Now, some of the questions we might have to ask is, so which one is your signature here? Because they don't look the same. So what do we deal with this? There's another issue which is the result of a whistleblowing, which pertains to, I think it's a contract for office furniture. I think it's under number 4. It was flagged, and the committee has been sent the report to say this is what specifically happened in this instance. Please address this concern, because information was taken from another bidder and allocated to another. I asked for the relevant contracts. You know what? The Road Accident Fund confirmed last Friday that the contract is active. So we have to ask, why was nothing done? I can move to this one because this one has been in the papers, the Moana properties. The whistleblowing is so detailed. The person says, I'm the person who had to change what had already been decided. Here are my emails. Here are minutes of meetings. They wrote to me yesterday to say, please get the police to protect me. I am feeling unsafe. They wrote to me. They wrote to the minister to ask for protection. So again, colleagues, these are matters I don't think we can keep every time there's a whistleblowing, we ask somebody to come here. And I'm just talking about the matters that we have received. The last point is what I will call matters relating to the rule of law. So once during the next day or two, and I'll work very hard to make sure that we synthesize all of this information, we've dealt with the Auditor General issue here. I am not quibbling with the issue of accounting standards. But in South Africa, we have a certain way in which state institutions take up matters that they are not happy with. First of all, I asked, okay, please send to the committee the internal legal advice that you obtained before proceeding to court on the matter. 1 sentence answer. There was no legal advice sought, and therefore those memos do not exist. We have spent, as taxpayers, nearly 20 million on that case. I think it's the business of the committee to follow up on that. The second point is, and I've made the example in the memo, other institutions find themselves in similar situations all the time. I've made the example about Eskom and NERSA's decisions. Eskom does not implement the new tariff structure because they disagree with NERSA. They say, we will take you to court. We will do what you want for now, but we'll ask the court to claw back what you did not give us once they agree with us. As it happens, in the previous round, the court actually agreed with Eskom, and Eskom was allowed to claw back. The only thing I'm appealing to members on here is this. We must think carefully about the door that we are opening, where if one state institution disagrees with the rule of an empowered state institution like the Auditor General, they can ignore it. The point here I want to say again, is not whether the Road Accident Fund can go to court to challenge the view of the Auditor General. They can. What we must be careful not to allow is a situation where, because we have to be consistent, Auditor General feels financial statements are not up to scratch. You made a loss. The institution says we feel we made a profit, and we are going to continue to present that here. I think the committee would be unhappy were that to happen. The final point that let's just complete the thing, because then I need to give the members an opportunity to comment. So what I'm saying is that the matters are too numerous. They relate to contracts, use of money, maladministration, and so on. And the proposal is this. We determine the terms of reference of such an inquiry. It has to relate to maladministration and so on. So it's not our job to deal with policy matters broadly, because that's the portfolio committee. There are lots of allegations and counter-allegations. everybody involved needs to get an opportunity to present their side of the story before the committee. We need to give everyone an opportunity to do so under oath. And having considered all written evidence and testimony, we then write our report. We reach our conclusions, we write our report, and we table it before the House. And those recommendations can then be implemented. The timetable proposes the following, because that also takes account of the timetable of Parliament. One, that as soon as the members have agreed broadly on the terms of reference, the committee secretariat writes them up. On there, is it the 30th that we can come back? The 1st of July. On the 1st of July, we do the same exercise. We look at, they get sent beforehand, we look at the terms of reference as proposed, and we finalize them. Then we use the period between July and the time that we come back from recess to prepare and also invite the various parties, because within those terms of reference, we'll also say who needs to come. And then when people come here and they testify, we have a consideration of all the evidence they place on the table, and then we complete our work. That will also give the committee space to deal with all these other institutions we see in the papers, and we get an ulcer, because there are also things that are bad that are happening there. It gives us a space to complete our work in respect of other things. So that is the way forward that I propose. The last point I want to make is the Ministry and the Road Accident Fund have sent us an enormous volume of documents with a document that sets out, it's got annexures and so on. During the course of this week, the committee secretariat and myself will synthesize all of this, prepare a detailed covering memo, and share all of that information with the members. The only information that will be redacted is critical whistleblower information, such as phone numbers and their names, because people have attached their names. Some of them have said, you can call us, but I have got this concern. So that's what we'll do, but the committee members will also get enough time to consider all of this information. So nothing will be hidden, basically, except information that we just generally want to protect. And then after that, when we come back on the 1st of July, the members would have seen the same information that I have seen. And we can finalize it. We can comment on the terms of reference, and we can finalize the terms of reference. And then we proceed on that basis. Members, let me stand down. But that's what I want to propose we do. Now, you've all had regard for the memo, so I am going to ask for comments. We'll start this way because the first hand has come from that side, and we will come this way. Honorable Atkinson.
Thank you very much, Chair. And I fully concur with everything that you've said. I just want to add that this is actually a deeply concerning situation, because the kind of amounts of money we're talking about could actually dwarf anything else that this committee has dealt with. It could make SAA look like a tea party by the amounts of money that are involved, and the potential liability that has been created for the state by the fact that claims have been rejected by the Road Accident Fund based on their legal board minutes and sent back to the people that sent them. The problem is that those claims that have been lodged with the Road Accident Fund, even though the Road Accident Fund might believe that they don't meet the criteria, actually might necessarily meet that criteria in law and could actually be valid claims. So what could be resulting from the illegal actions, the illegal board minute, is that a liability is being created on the state that at the moment we can't quantify, but it could run into the tens of billions of rand. Not only that, but we have also seen through the issue of some of the contracts and various other aspects, the amounts of money that the Road Accident Fund gets in from the fuel levy. We're talking about considerable amounts of money, and that as you're saying, there are large question marks over how some of that money, where it sits, because the CEO wasn't keen to tell us exactly where that money sits, which, I mean, as a public entity, he does need to disclose that. So what I'm saying is I think there's a great interest in the public Because if you recall in the last budget, the one increase that the finance minister did was to increase the fuel levy. And the fuel levy is exactly what funds this road accident fund. And I believe if we can get to the bottom of the corruption and the waste of money, that increase in the fuel levy might not even have been necessary. So in essence, the public of South Africa are paying for corruption and maladministration at the road accident fund through an increase in the fuel levy which they're experiencing. So this actually touches the pockets of every South African. So I believe it's critical that we actually get to the bottom of it. With regards to the issues of the fact that the officials at the road accident fund have been less than open and honest with this committee, another factor has been drawn to my attention that at the last meeting, the acting CEO of the fund basically said that 3% of all claims were default judgments. By going through court orders and the court papers since January this year, that figure is closer to 87%. The Road Accident Fund doesn't have the IT sufficient to be able to differentiate between a court judgment and an agreement. So they actually don't really know themselves. But if you look at the court paper, if you look at the records of all the judgments that have been given, 87% are default judgments. So the variation between what we've been told and what the reality is vast. I mean, one could forgive it if he said 20% and was actually 30%, but between 3% and 87% is actually a shocking misrepresentation of the situation that we face with. The other thing that I'd like to ask for is that when it comes to the terms of reference, I'd like us to look at the employment of Mr. Collins Letswalo and whether that actually is a valid employment. Because the reality is that we know that for 7 years he's operated without security clearance, which completely goes against the terms of his contract. And what we've been told is that he wouldn't go for the polygraph test. So in essence, he was mala fides. He was in bad faith. And my understanding is that if you're in bad faith, you invalidate your terms of your contract. So the fact that he was binding the Road Accident Fund in these legal actions against the Auditor General, he may not actually have had the legal standing to be able to do that, because if he wasn't a properly appointed official, if he didn't meet the criteria for his appointment, it raises huge questions as to whether he could actually even act on behalf of the fund itself. So I would like that to be one of the terms of reference, is to look specifically at Mr. Collins Letswalo's situation with regards to his security clearance or lack thereof, and where that leaves the fund legally, and whether he actually really ever was legally appointed. Because the fact that, as I said, there was a mala fides action on his behalf not to get the security clearance done. Chair, I go with everything that you said, that there has been a discrepancy between what we've been told and what the facts are of the information that we've been getting back from from the whistleblowers as well. So I think it's a critical factor that we take the bull by the horns here, that we do set up a committee inquiry into it to get to the bottom of what the situation is, and also to try and get a handle of the potential liability that might be out there as well. Because, we're talking about the fact that it could be tens of billions of rand. I think the state has got a huge problem here. And I don't think we can actually ignore it any longer. I think as a committee, we are required to come to the defense of the people of South Africa, because this is really what it is, and the complete waste of their money through corruption and maladministration. Thank you.
Thank you. Yeah, we're just going this way. If a member wants to pass up the opportunity, you can say.
Yeah, thanks, Chair. So I fully agree. I think the liability at the RAF it's massive, and that's why they keep fighting the Auditor General, because they don't want the true state of their accounts. And I think you've been very kind, saying we've been lied to, Chair. We've been lied to by the board and by the CEO, and I think that they've crossed a line when it comes to that. But including in the terms of reference, Chair, I would also like to include is that we've got to celebrate and honour competent people in these organisations who put their hand up. And my concern is that the RAF has used state money to bully competent employees, and I think most of us agree bullies are the worst in society, because they're just destroying lives, Chair. And I think I would like to have included in the terms of reference that particular clause is people who've been dismissed, and the RAF have used state resources to prevent these people coming back, and actually destroyed lives of competent, decent human beings. And I think that is the lowest form of power, when one can actually use state resources to stamp on somebody and destroy their lives. Thank you, Chair.
Morning, Chairperson. Morning, my colleagues, and everyone present here. Chairperson, I wish to express grave concern regarding the conduct and governance of the Road Accident Fund, particularly under the current leadership. There are serious allegations of abuse of power, financial mismanagement, disregard for legal processes, and undermining court procedures. Just looking at the maladministration, the media spread, the Clarkway projects, and many more. The inhuman behavior of the CEO against the shop stewards and persons that are working for the RAF. It is absolutely unacceptable. These actions threaten the integrity of the fund and its ability to deliver justice and compensation to road accident victims. I'm therefore proposing that this committee urgently considers launching a full inquiry with the committee inquiry, Chair. I think we have no other choice. And let's see from there. It is just unbelievable. Thank you.
Yeah, no, thank you very much, Honorable Chair, and good morning to everyone in the meeting. Yeah, no, Chair, we support your suggestion to have a full inquiry into matters of the RAF. Because I think we've said with the board and executives, with the deputy minister, I think twice, if I'm not mistaken. In some instances, the board and the executives with the CEO, they would agree on matters. But in other instances, they would contradict each other. And in our last meeting, it would also appear that the board was not sure of what they are doing in terms of handling their matters, including handling the matter of the suspended CEO and so forth. I also followed their interaction, the interaction of the board with the Transport Portfolio Committee and the interaction between the Transport Portfolio Committee and the suspended CEO. So there are quite a number of grey areas in terms of the operation of that particular entity. There are quite a number of contradictions and so forth. So I think it would really assist to have an inquiry because the benefits of having an inquiry is that we are able to have a conversation with other people outside the board and the executives, maybe people who are in the employment of the RAF, maybe who are below the executive levels, who've got information that they would want to share with us, would also be able to have a conversation with external stakeholders, maybe who are doing business with RAF or who had done business with RAF at some point, or any other person who would have any information that relates to RAF. So it will really broaden our understanding as the committee to hear all different sides of the story in relation to this particular entity. And it will also help because if we do an inquiry, everyone who will be speaking under oath, unlike now when we just invite them for a committee conversation. But if it's an inquiry, everybody will know that I'm speaking under oath. So I must make sure that what I'm telling the committee is truth and nothing else but the truth. And I think you have reminded us of a number of inconsistencies where they would say something and then next time they would come and change it and all that. So I think if it's an inquiry, everybody will make sure that whatever he or she says before the committee, he or she say that under oath. Amongst, I think, another issue that there's a quite the volume of these documents that we have is quite a lot. It's not something that we can just sit in a meeting and take a decision. We may arrive at a wrong decision, but if we've got an inquiry, we'll have enough time to read the documents and then interact with the relevant people, so that at the end of the day, we are able to take an informed decision and make proper recommendations to the National Assembly. For instance, I was looking at one case, it's because it's a shorter case in my view, the issue of Mr. Victor Songelwa, who is the General Manager for Finance, who received a letter from lawyers that his contract is being terminated before time. His contract was supposed to end by end of September. So he received letter from lawyers, not from his supervisor within the employment. He received a letter from lawyers. It's a person who's not been charged for anything, has not undergone any disciplinary hearing, but they are saying, no, we are terminating your contract 5 months earlier. However, we're going to pay you. So we are not going to suffer because of this, because we are going to pay you up until the end of September. But then the question that if you pay this person sitting at home for 5 months, is that not a fruitless and wasteful expenditure? And who will be playing the role that this particular person was playing in the institution? Because this person is sitting at home for 5 months, it means somebody else must come in and act and also be given an acting allowance. So it means the organization will be incurring fruitless and wasteful expenditure without clear reasons as to why is that done. So I think these are some of the things that would, as the committee, I think would be interested to get more information from him, but also from the institution to say how can the institution take a decision like this, especially when the person has not been subjected to any disciplinary hearing, has not been charged with anything. I think it was going to be a different case if this person was charged for a certain misconduct, has attended a disciplinary hearing, and therefore they arrive at that particular decision to say, we don't think we, as an institution we can be able to work further with you. So we decide that let's terminate your contract. But here it's a person who, according to him, well, we have not heard the side of the story from Raf, but according to him, he has not been charged with anything, he has not attended any disciplinary hearing, but he just received a letter from lawyers. I mean, when lawyers are involved, it means there's a dispute. But now, this person, there are supervisors who are supervising him, but they get a letter from lawyers that says, no, we're ending your contract within 3 days, but we are going to pay you up until the end of September. No, it's not about him being paid, but it's about the resources of the institution, that somebody must go and sit at home and get paid for nothing. And then somebody must then come in and act and also get paid. It's a serious problem. So we would like to get the side of the story from the RIF, but also get more information from him. So these are some of the things. There are quite a number of cases, I think, that we do have. But these are some of the things that will make it necessary for us to have that kind of a conversation and inquiry to get more details on issues like this. So we fully support that proposal, Honorable Chair. Thank you very much.
Thank you very much. I'm going to come to you, Honorable Nondenja. And this is one of the correspondences I will share with the committee. There are two. But one relates to Mr. Songelwa. There was actually a labor relations dispute between Mr. Songelwa and the RAF. He won at every stage. So the litigation is now complete. The RAF has been instructed to reinstate him. Rather than do that, they've told him to sit at home. And so there is a judgment, actually, that we can furnish the committee. The second case I received on Friday. It relates to a Ms. I can mention it because it's in the public domain. There's a court case. The matter has gone all the way to the Labour Appeal Court. Ms. Plope from KZN was disciplined for asking whether she can ask a question in a meeting. She was dismissed, won at the bargaining council, or at the CCMA. The RAF appealed to the Labour Court. The Labour Court ruled in her favor. They then appealed to the Labour Appeal Court. and the Labour Appeal Court ruled in her favor and levied punitive costs against the Road Accident Fund. She attempted to come to work 3 times. On each occasion, she was turned away. She must now go back to court to get a contempt order so they can reinstate her. She says in her letter that she has been hospitalized, she's on chronic medication, she's got suicidal thoughts, I can go on. Now, we can't ignore this because we've also got to ask, is this an efficient use of state funds? Is this the only case? And when you consider that the institution has lost 28 lawyers, who is advising you on these matters that then proceed to cost money? So one of the things the members will see in the letter, I've asked them, how much have you spent in the last 3 years on labor relations costs? It's close to 50 million that they've spent. So I was just correcting that fact, but also saying that's an area that I think the committee needs to inquire into, because you don't have a head of HR, you don't have a head of legal, you've lost 28 lawyers, you are litigating. So who makes the decision? And there's no regional head. So who decides? So these are the questions that I think an inquiry would help us to settle. But factually, there was a dispute. It went all the way up the chain and the person prevailed. They just don't want him at work, so he's now sitting at home getting paid. And his salary, as I understand, is well over 1.5 million per annum. Anyway, Honorable Nontenja, sorry.
Thank you, Chair, and good morning, colleagues and everyone. Chairperson, let me start by thanking you for compiling the memo for us. You really made our work a lot easier. Thank you. Chair, this institution seems to be a law unto itself. It's taken to court, there's a judgment, and it just ignores all that. So we really support your view that there must be an inquiry. And the fact that they are, beside contradicting each other, they are not forthcoming with information that's requested. And if you look at what comes from the whistleblowers and what they can give, there's a huge disparity there. I would request that the inquiry must include a forensic audit, because from where I'm sitting, I don't think the HSA also has everything that it should have. Besides, we know that when they audit, they would take samples. They don't really go deep. But this institution is calling for a forensic audit because they're hiding something, and it's something huge. And they are just doing as they please. I just hope that having inquiry will give us a way of getting deep to the roots of what is really happening there. It's amazing how they get away with everything, and it makes one ask questions as to when the AG's office sees this year in and year out, and they continue to use their preferred standards, not what is approved in the country. They take their own route, they do as they please. It's really something that calls for action, and the sooner the better. Thank you, Chair.
Honorable Skosana.
Thank you, Chair. The issue of REF, it's touching a nerve of many people in this country, I must say. There's a lot of interest in this matter. For a simple reason, money. Nothing else, money. When the CEO was sitting here telling us that he saved just over 20 billion rand, some of us applauded him to say he has done well. Some might not have done that for whatever reason. But the issue and the facts is that the CEO and his team saved this country over 20 billion rand. No one can deny that. It was factually proven here in this committee. With all the things they have, I've seen recently a circus from the minister, deputy minister, to the board, to the executive itself, to the management itself. My concerns here, Chair, I'm seeing the names of companies here, but there's other names which are not here on this report. Perhaps the Chair will exactly tell us why these other companies are not here. I'm talking about these lawyers' firms, these attorneys' firms here. Some of them are not here. And perhaps for a reason, that's why perhaps you did not pen them down here. Because I'm seeing few companies here. And I guess even the name of these media companies has to be here. You know, what you call it, mixed 360 or so. These media companies, which were awarded 1 billion rand tender for media. There's two companies, I think it's Giengo, but they should be here. The names should be in here as well. People should not guess who are those companies. Whether they look dodgy if you check the directors in those companies, but their names should be here. Those names as well of Bowmans and Versmen, they should be here. We must know exactly how much have they benefited from REF. Nothing must be hidden. We must know exactly who is milking this institution. Not necessarily milking per se, perhaps they deserve to be paid all the money which they are claiming here. But we need to know them. Nothing should be hidden here. Everything must be here, because we are saying people should really account here. The issue as well, because as I said, Chair, I'm seeing Malachi, and again, you know, Mponyana, Litwaba, and whoever these companies are. But I must say to you, Chair, where I'm sitting. As I said earlier, these big firms are not here. And I don't know what was the reason, Chair, why these big firms' names are not mentioned here. But at a later stage, when the Chair is wrapping up, perhaps you will give us the reason
I will
why.
respond substantively. Thanks.
On that, yes. And this issue of, there's an issue which has been going on, you know, about the Auditor General and REF. The IPSA issue, the GRAP issue, and the issue of courts. I want to reiterate once again in this committee. Whether the court has rejected your appeal, you have the right to go to the highest court of the land, the Constitutional Court. And I said it here when the Deputy Minister was arguing, telling me that he started here, I don't know how long, you know, he's got experience, you know, maybe we don't have experience because it's a 1 year. And I argued to say, you might have a service of 10 years, but no experience. You might sit here for the last 3 administration, but that does not mean that you've got experience. You might have been sitting here doing nothing. Now, this issue should not be like now we want to dictate. When somebody has to stop going to court, if he goes to the Constitutional Court and he fails there, so fine, no problem, the matter is closed, whether we like it or not. But it can't be the matter end up at the Supreme Court of Appeal, then it's the end of the story. If the team, the top management, not necessarily the CEO, because he's not operating there alone, can save 20+ billion, then we are here to debate about 50 million. For me, that's being indigenous for me. For me, I'm saying here, to say, irrespective of what other people are thinking about this issue of ref. The issue here is not about that, Chair. It's more about lawyers here and doctors and these big firms. The discoveries of this world and others. It's a fact. Now, Chair, can you protect me once again? Thank you. Before I continue, because I'm getting offended, Chair. Okay.
What happened? Honorable Mente?
No, Chair, it's a point of order, Chair. And seriously, some of us, we really don't want to degenerate to a level where other people can go to. We can go there. Honorable Skosana, yes, Chair, I understand when you are focusing because you are busy taking notes of what we're saying. The two members of the DA, they keep on, they keep on speaking over him. Their dissatisfaction of his facts are very clear. I'm not saying they must agree, but they must just keep quiet and listen. We listened to them. They must not invalidate the concerns of Honorable Skosana. They must stop doing that. Thank you.
Okay, I didn't hear, but...
Chair, would you give me an opportunity to respond?
Sure.
Please? I'm tired of being told that I'm invalidating people's positions. The colleague is borderline shouting in this committee. We are quietly at moments whispering information to each other. If we're not afforded that... sorry,
colleagues,
don't tell me that I'm invalidating
No.
you and then you go
Again,
and do exactly the same thing to me.
colleagues, can we speak to one another with decorum, please?
No, but
Okay, so- yeah.
the hypocrisy prevalent here is a problem. Like, literally the person who brought this issue up is interjecting while I'm speaking. So either we afford each other the privilege of speaking to our colleagues or we don't. But this nonsense the whole time is entirely unconstructive. We're sitting here doing the minimum viable amount of talking to each other while our colleague is shouting.
Colleagues, can I just ask once more? We agreed in the beginning that we're going to give each other the opportunity to finish our points. I accept that sometimes we may need to say things to one another, but that must be done in a way that does not disrupt the proceeding. I did not hear anybody speaking. I'm busy taking notes here. I may have missed it, but I didn't hear. But can we please, colleagues, just allow each other to finish? And we're almost there. There are two members left after Honorable Skosan.
Chair?
Sorry, Chair. He can't be referring to me as I'm speaking to nonsense. Not going to be told by some useless white boy that I'm speaking nonsense.
Colleagues, can we just come down?
I'm sorry, but I've
colleagues,
constantly been referred to in racist terms today.
So-
It's not acceptable.
so colleagues, wait, please. Colleagues, please. Colleagues, can we treat one another with the necessary decorum, firstly? And secondly, can we respect the public who are watching these proceedings? The matters under discussion are serious. Like I've said, I accept that colleagues may want to whisper something to one another, like Honorable Neil May and Honorable Skosana are doing right now, right? That's fine. But let's do it in a manner that is not disruptive. And I didn't hear the disruption from Honorable Beck and Honorable Atkinson. And I did intervene earlier when I felt that I could hear what Honorable Mente is saying. So colleagues, can we please give Honorable Skosana an opportunity to complete his presentation to the committee, because he's on the floor. And members, let's please refrain from calling each other names, please. Please.
Chair, let me start here. I heard them, but I'm not going to go there. But I just want to ask. The honourable member said somebody shouting. Who's shouting? Can you please answer that to you? Before
Colleagues, Honorable Skosana, please. Can we please proceed?
My simple question. He says to you, somebody shouting. Who's shouting here?
So we must.
I just want him to answer because that's what he said to you.
No, he was referring to you.
So are you agreeing with him?
No.
Am I shouting?
We having a conversation, Honorable Skosana.
No, but he's saying I'm shouting. We are having a conversation, but he's saying I'm shouting.
Honorable Skosana, can I say this?
He's saying it again. I can say.
Colleagues.
No, I'll point at you.
Colleagues. 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 No. Honorable Beck. No, you can't say that. No, but you can't say to another member, let's take it outside, please. No, Honorable Beck, that we, so, colleagues, no, hang on, colleagues, can I, no, but you're not.
If you don't discipline him,
you're not allowing.
Let me tell you, this meeting is going to degenerate to what he wants to. He says I must go. I can go outside. I don't mind.
But you are not allowing me to speak now, Honorable Skosana, myself.
This young boy.
But honorable member, this is the problem. So where are you going now, Honorable Skosana?
No, let me take a break.
Allow him to follow him.
No, colleagues.
He's undermining us. He's believing
can I? So, colleagues, can I deal with the matter? Honorable Skosana, the matters pertain to you. Can we have you in the room? Okay. So Parliament is a place of robust debate, Honorable Beck, and sometimes things get heated. It is, however, not appropriate to say, let's now go to physical. No, but taking it outside as a connotation that people understand.
When you call somebody useless white boy, that has no connotation. That has a direct meaning. Don't take an issue with that. But somehow me insinuating that we can take the conversation outside is more of a problem. Can you be consistent?
Honorable Beck, I have dealt with the matter of how the members refer to one another. I did. No, I dealt with that, Honorable Beck, and I also said in my intervention, if you want to, because we've dealt with a similar thing before, in terms of the rules, if you feel that what Honorable Skosana or any member said, you can put it in writing. So that did not take away the right from you to raise the issue. I did say in this meeting. Right, okay, so that's the first thing. The second thing I want to say is that it's just important, colleagues, that we maintain that the issue gets very heated in the public domain, on social media, and here. What South Africans expect us to do is to be able to deal with the differences in a way that gets us to a conclusion in the conversation, right? My position is members may pass each other notes as it is allowed. They may whisper to one another. It's allowed, and it does happen, and I stop it at a certain point. But not all whispering is not allowed, right, firstly. And secondly, when it gets to a point where it is being disruptive, I will intervene as I do from time to time. Can we please give Honorable Skosana a chance to complete his presentation, please? Because we're going to go down this rabbit hole and never finish this topic, please. And we can deal with the points of dispute thereafter, if any.
Chair, let me give it to my colleague. You know, I think I must stop here.
Thank you, Chair, and greetings to fellow committee members. I think this committee is a very interesting committee, and it's a very cordial committee. I want to first start by supporting the recommendations. Maybe let me start there. And I think it is important because we must at all times.
I owe Honorable Skosana an explanation in terms of the things he placed on the table. And because we had this, I think him and the public deserve to know the points he raised are valid in terms of what is declared in the memo and what is not. Can I do that? Please, I would like to do that. So, Honorable Skosana, the names that I have disclosed and not disclosed, are on the basis of the following. The law firms like Malachi and so on were already canvassed in the committee here in public. There was a list presented, it's a public document that is available. The discrepancies have arisen thereafter, but the names and so on are in the public domain. That's number one. The names that are not mentioned in the memo, and I will say what those names are now, is that what I do, just for rigor, when someone sends to the committee an allegation to say there's a contract like this and a contract like that, and typically what these whistleblowers do, they copy the whole world, Sunday Times, and even people who are no longer journalists. I then write to that institution and ask some questions. Does a contract like this exist? What is the amount? And so that's what I did in the case, for instance, of the media companies. It is in that response that came on late on Friday, after I had shared the memo with the members. The two companies are Media Mix 360 and Zinge Productions. That's the only reason they are not in the thing. I wanted to make sure that what the whistleblower is saying does exist. Otherwise, we put them here and then it turns out there is no such, and we might have then put them in difficulty unnecessarily. I also asked them the value of the contracts. The Road Accident Fund sent it to me. I asked them for the contracts themselves. They sent them to me. I then compared. I could not do that at the time I was dispatching the memo because time was running out. Because another issue then would have arisen where I have now put their names next to a figure of 1 billion, and then it turns out it's actually 300 million or 30 million. And then we bring them into disrepute in that way. So that is the reason why I didn't put their names on. But in this indexed file that the committee secretariat is going to provide, not only the names, but the contracts themselves will be in there so that you can also compare yourself that what is put there is indeed the case. The other law firms were already in the public domain. Already when we were here, I don't think you were in that meeting, but they were canvassed in the meeting. I think it's when you went to the SADC mission, so they were already canvassed. So that's the type of rigor I try and put into the process of what we disclose at what point, and I was not comfortable disclosing them without getting a confirmation from the RAF that they are indeed. So I then didn't say them. But the whistleblower copied about 30 people in the files that they sent to me. So I couldn't therefore have control over what gets said beyond that. I hope I've answered you.
Thank you, Chair. You answered me, though, the issue of the other companies like Vexman, because we were here.
Yes. No, thank you. Thanks for reminder. Let me deal with that. So they were presented to the committee. Nobody in the committee disputed those numbers. I did not. None of the members disputed them. In fact, the very point of the dispute is we had asked the Road Accident Fund for two lists. One is the attorneys the Road Accident Fund talks about and say they represent clients, they make all of this money. The Road Accident Fund itemized what the total expenditure. It's already on the parliamentary record. In the event that you feel we must delve into those issues, it's already there. None of the members disputed it. I didn't. It's not in dispute. It's on the parliament record. And therefore, for me to relitigate it again as something the committee did not know would not be accurate. In the previous meeting, when you could not, in fact, the one in March, the Road Accident Fund presented to us a list of 10 attorneys. All of these law firms that you're talking about were there, including the specific amounts they have received. That's on the public record, so it's not being hidden. Then let me go to the issue of the Road Accident Fund and the court case, and just clarify myself because it can be misconstrued. The Road Accident Fund, Eskom, or anyone has a right to litigate all the way to the highest court. There is a process, however, that attends to that. I made the example in the memo about Eskom. NERSA made a determination. Eskom disagreed with it. Eskom took them to the High Court and eventually to the Supreme Court of Appeal. I have read both judgments. What Eskom did was to say, if you do not want to give us the price determination, we will appeal it. We will do what you are saying so long, but we are going to litigate you until we win. And they did, and they won. That's fine. That's not the issue we are dealing with here. What the committee has to opine on is whether, if we are to be consistent, we are going to say, when a state entity disagrees with a body, either like NERSA or the Auditor General and so on, they may defy it because they've chosen to litigate. Eskom did not, but they litigated. So I want to assure you that my proposition here is not about whether the Road Accident Fund can litigate or not. They can do whatever they want to do, and we've canvassed that in the committee. However, we will plunge the accountability system into chaos if we say, whenever you disagree with the AG, you can continue doing your own thing. It makes the work of the committee invalid, right? We trust the AG. We said here the AG is the first wife in this meeting. We said the AG is the first wife. We asked them first, do you agree or not? We've been going with that. We must be careful about creating exceptions. So I'm just saying, Honorable Skosana, the RAF can go to the Court if they so wish. That's not the issue at hand here. The issue is whether the committee agrees with a situation where a state entity then says, because we disagree with you, AG, or we'll do what we want to do in the meantime. Right? That's the issue. I'm just explaining the issue. We may then, as part of the inquiry that we are going to have a witness here who deals with that matter. Right? I'm placing this as an issue on the table. We can have a conversation then that helps us inform us in terms of how we become consistent. That's all I'm saying. I'm not saying the RAF should not litigate. I hope I've clarified all of those issues. Sorry, Honorable Matlala, I felt I owed the Honorable Skosana an explanation. He had raised specific issues.
Thank you, Chair. So I was still saying, let me start from the end and say the recommendations you have made, that there must be maybe an expanded proclamation, that the AG must do certain audits. I support them. And then let me follow up with some of the inputs I want to make on this matter. Firstly, I want to say that the issue of RAF, I think, has been a test of this committee. It's a test of oversight. It's a case study which would have to be reviewed and studied at some point in the academic spaces. And there are certain elephants in the room that need to be dealt with. The noise in most cases starts when the parties in opposition or representatives of parties in opposition start to articulate their view. And in saying that, I must also say you have made a very good effort in remaining objective on the matter, despite a feeling that I would probably have, that maybe parties in government have agreed on a position around the matter. In some way, that's my own insinuation, which may be wrong. So, and as a member of Umkhonto weSizwe Party, I don't stand here believing that RAF is performing optimally, or that there's proper governance in RAF, or even administration for that matter. Maybe let me start there, because I hold the view that there's a total collapse of all institutions, and RAF is no exception. That is SAA, that's DENEL, that's public institutions, Department of Education, higher education, agriculture, health, everything, having sat here for the past year. There are institutions with disclaimers for over 5 consecutive terms. But the issue of RAF seems to have a peculiar approach. It seems to have two ends that wants to exacerbate their position on it. One end appearing to be saying it is the worst form of administration that has ever been seen. The CEO must go. It must be worked around and all of that. And another end maybe appearing to say the contrary, to say the CEO is doing exceptionally well. these issues that are raised here, for example, around the filling of vacancies, around certain allegations and all of that, are a concern, a serious concern. We have seen them also in other institutions. There's nothing new that we are seeing in RAF which we have not seen in other institutions, except maybe court cases and all of that, which are peculiar to the business that RAF is doing. However, we have not been seen to be taking as much radical approach to how they need to be addressed as we seem to be doing. So what I'm trying to narrate is driving at a point where it is important that there is a structure legislated by government to do investigations, so that we don't try to turn this committee into an investigative forum or a commission of some sort. Because we do not have all the, I think Honorable Skosana did mention that, we do not have enough time to say, let's sit over 2 months, call in whistleblowers, interrogate evidence, arrive at some subjective and scientific truths, or probability at least, of what is the situation. But we can formulate an opinion that there is a dire situation and an urgent need for a government intervention. But that intervention must be an objective intervention. There have been many inconsistencies, Chair, as you indicate, and I would mention one also, because I want us to, as we move forward and as we try to ensure that the public continues to have confidence in our objectivity to do our fiduciary responsibility and governance oversight, to be as objective as we can. Because one example is the issue that we ventilated in the last sitting, where there was a deputy minister here, where the RAF board came and said they made a decision to put the CEO on special leave. We educated them about the difference between special leave and suspension. The deputy minister insisted that a special leave was the right decision, and that even the board, as a legal person that sits in the board. A few days after, in fact, I even cautioned the deputy minister in that meeting, and I said, I feel like you are responding more on issues that are decisions of the board, not your decision, because you don't sit in the board. Well, he defended himself, and I let it slide. But 3 days after, they say they consulted lawyers and arrived at a decision of a suspension. And that says, in the process, there is some level of interference. It may be minor, it may not be as or deliberate, for example, or for that matter, but there may be levels of even interference from people outside the board and executive. Because we speak about exactly a subject that we tell the minister, the deputy minister, the board and management that it was a wrong decision. And there's an insistence on it, and then 3 days after, it is corrected. And now that tells you that we are not operating in good faith. So there are many irregularities. Others, we are highlighting them as having came from the CEO. Others were exposed in the transport committee from the board, and admissions were made. But in many other instances also, we have sat here with the Department of Military Veterans where the acting deputy director said verbatimly that there is interference from political people. That is why she can't run the department. We have never taken any other decision after that. We'll probably consider it as a committee in future, but it stands. As we speak, she's there, acting, having the interference and unable to run the department. And it's business as usual from our side. But we're ventilating and we're taking hours on RAF matter. And I'm just saying, let's try to find a way in which we take this to some people who are with the competency to ventilate the matters. And when we then come back to deal with the reports, try and be as objective as possible. From a revolutionary approach as a political person, there are certain principled issues that I agree with, which the CEO is implementing at RAF. But also from a procedural point, I may also agree that you do not implement before you get the approval of achieving a strategic decision. So, for example, if you say that the compliance with the accounting standards are saying ABC, whilst you may be correct in saying that there should not be that, but in the meantime you comply. I'm saying, for example, there is objectivity. That is beside me understanding that the system has got flaws, and we are challenging the system as a party in opposition. We disagree with it in totality, including the monopoly industries and all of that. So let's try not to cloud our political motives with our administrative responsibilities and try to maintain an objective posture, so that at least we can be able to take the public into confidence and remain being a competent committee to hold these institutions accountable. Otherwise, at some point, I'll be tempted to arrive at a position that we may not be competent objectively. We may not be at an objective point as a committee that we can make decisions or recommendations on this particular matter because of how inconsistent we have not been on worse institutions that we have seen here. Administratively, I don't think RAF is the worst, having sat here for the past year. But we have taken 30 times the hours on the issue of RAF, and because of these other issues. So I support your recommendations. We pack it, we allow for those proclamations to go on with someone, and also in bringing people to account to the committee, and I think everyone that would have summoned, if we arrive at that point, which is the last bullet, second last bullet, would have to be under oath, I think. Board has got issues, management has got issues, and we need them under oath and consider what if there are breaches of information that comes from that meeting. Otherwise, that is my position, Chair, and an appeal to you, to the committee, to say, in as much as possible, no matter how heated the discussion is, at least let us try to be consistent. And let us try, and I admit, I respect the silence as I'm speaking, you know, because I've also been silent when everyone else was speaking. I think we can still achieve that kind of cordiality, and also we can be able to be consistent even with fellow disciplinarians like Kosana who know the rules, and apply it consistently when it's members of their own government who are doing that, and maintain the decorum of the meeting. Thank you, Chair.
Thank you very much, Honorable Madlala. I take all the points that you've made. I'll just make 2 or 3 to assist. The first one is that it is possible that our colleagues from within the government may have spoken, but they didn't talk to me. That is not what is that is informing me here. I did at the beginning of the meeting to say I get various whistleblowings. It's really gotten to the extent where I have asked Mr. Balfour to assist me because there are so many. And there is a problem when then members of the public feel that I am ignoring them. You understand? And the volume of information, so I can't ignore. I then have to write to the institution and say, what's going on? Because I don't want to bring it here always, right? It's gotten to the point where I am at the risk myself of spending 50% of my time outside of this committee on RAF matters. That would be a misallocation of my time. I should not be doing that. So the shortcut I am proposing is that so that we can move to the very issues that you're talking about. So one of the things that is on our radar screen, there's a newspaper article about PRASA fixing things and then not doing anything with them. They have to come to the committee and account. If we're always dealing with the RAF, they're never going to come here, and then the perception of bias is actually going to get worse. So the reason I think we are aligned in a sense to say, so that we have time to attend to these other matters, let's deal with RAF once, just due to the volume of the issues. Once we make recommendations, we then hold the executive accountable from then on. I think the inquiry will also give us an opportunity to place the Deputy Minister here and ask him questions about the observations that you are making, right? So I've considered the same, Honorable Madlala, as well. But I am overwhelmed, I have to say. I have a folder on my email only for RAF. It takes too much of my time. I can't, you know what I mean? So that's, I think we are on the same page, Honorable Madlala. Otherwise, we'll have them here every month and people will ask what's going on. And that's my concern as well. Thank you. Honorable Member.
Thank you, Chair. Chair, I'm going to go straight to the points. Firstly, Chair, let's appreciate you paying attention to the people when they are appealing to parliamentarians and public representatives to ventilate their frustrations and the maladministration that's taking place in our government. And in most cases, it's people that are within the space of government that will always blow a whistle. Be that as it may, now I'm getting to a point where when I receive these documents and I'm like, okay, but I'm worried about then priorities of the committee. And I get your frustration that you want to deal with RAF once and for all. and afford an opportunity to both the CEO and the board to all state their case and bring evidence thereof, of whatever has taken place. But my worry is our priorities and the focus and things that we want to elevate, because constituting a full inquiry on an entity that's primarily focusing on less than what, 2% of the population. I mean, in terms of those that get affected by accidents, not necessarily their mandate. It's less than 2% people that get affected by accidents and they have to claim. Then we have people that get affected by service delivery everywhere, and they have been brought to us. Case in point, we were just recently in OR Tambo. Me and you, we agreed a lot in many things. We even brought people members of the public to come and tell us how rotten the government is, and services that don't get to the people, officials that do not implement the mandate, that do not perform, but money is leaving the coffers with a speed of an eye blink. And with those matters, the Speaker also again gave us some of the municipalities where there's serious concerns of maladministration, people do not get services, projects not being finalized, to a point where nothing is getting to the people. Now, for someone who's outside this committee, and we try to explain, we are now starting an inquiry on RAF when there is municipalities that do not perform at all. And with the example I just made is that what made things worse is the recent floods that befell the Eastern Cape, and in particular KSD again in OR Tambo, where the municipality could do zero, simply because they have absolutely no capacity to do anything. Not that that capacity was not in the plan. It was in the plan, paid for, but never materialized in terms of the actual equipment being there for the people to make use of. To a point where people were only saved 6-7 hours later because we're waiting for divers and equipment and everything. That was 6 hours away in Gqeberha, in Durban, and all of those things. So I'm trying to persuade you, Chair, to say, yes, there are matters at draft footy. No one can ever argue with that. But in terms of the volume of the cases of people we see on a daily basis, I do not think it will be fair for us to have an inquiry based on an entity that's just servicing a few people. Yes, we will pay attention to it the best way we know how, but a priority of that nature, maybe if we were to be given an opportunity for all of us to say, which area should we prioritize in order for us to make an inquiry which is based on how our people are suffering out there, I wouldn't pick RAF as the most number one of them. Then number two is that the issue of the accounting standards. In the previous parliament, the issue was dealt with a lot. And RAF was cautioned and cautioned. And I remember very well when we started parliament in our first meeting, where we were getting to understand what each government institution, and in particular our wives as COPA, are going to assist us with first wife, second wife, and the third wife. It was AG, Treasury, and SIU. So when we met with our wives, as Tembu said, the first thing I asked our first wife was, there's a matter of RAF you people have to resolve, because we dealt with this issue. RAF is raising its own pertinent issues on the issue of accounting standards. And it's been made clear various times, Chair, and I agree with you, we cannot have a favorite that must not follow the law. The law is law. That goes without saying. But when there are issues within the scope of accountability and how the situation at RAF in particular, having been not an insurance, but money that's there sitting for whoever has an accident, which is not predetermined as well. We don't know how many accidents we'll have today. We don't know how many claims we'll have today. So if you have 1 million rand and then you have 5 million worth of accidents, there's nothing you can do. And that's what RAF has been saying. If we have 1 million and then there are claims that are above 5 million, and it's beyond their control. So in that spirit, I asked the first wife, have you now gone back to look at how best yourselves, RAF, ASB, and the executive, you can deal with this matter? Because ASB has been to Parliament to explain how can this matter be tackled, and they had the resolution on how it can be tackled. AG explained and said, yes, there can be a matter, but it's not their space. The space is ASB and the executive. And the executive also agreed that, okay, stop taking AG to court, now account, but let's engage the ASB so that it can formulate the standard which is suitable for you to account, and we don't have this matter. So this matter is a matter that has been canvassed a long time ago. And I don't think even after our inquiry we're going to resolve it, because the matter will always be there. Whether it's Collins Litwalo or it's Veronica Mente or it's Songe Zuzibi, if that one of the accounting standards is not corrected, the matter is not going to go away. We can have the inquiry, but in terms of accountability, we need to resolve a matter of how does RAF account? How does it budget? How does it use its income and expenditure? How does it document it? And that's what it is. Now, here is my other problem. The same AG comes to us and say, yes, with all these issues we have in terms of our 3 areas of audit, the financial statements, there's still a huge disagreement that these people do not comply with the accounting standards on how they are drafting the financial statements. Therefore, the financial statements are not drafted up to standards. Yes, we all agree, and that must be corrected. Secondly, on performance, they say this entity performed exceptionally well. From 180 days to 120 days, the backlog being dealt with, everything being dealt with, money has been saved. We all applaud, we are happy. It's AG telling us, the same Auditor General, telling us that the current management at RAF with the board have taken decisions that have saved the country so much money. Part of those are what happened when the what was that panel of lawyers term or contract ended. It was not renewed. That became a big hullabaloo in the last parliament, that no, it must be renewed. Those people were not saving RAF, but they were plummeting RAF into much deeper crisis, because cases were prolonged to such a way that every time there is such a backlog of cases that must go to court because they are not finalized within 180 days. Now, the issue of 180 days is being dealt with. No one is going to court for that, for delaying claims. We are going to court for claims that have been there. Secondly, there are law firms that are there that have been taking money out of RAF because of what the work that they are doing and all of that. It was explained to us. It's millions, and then top 2 or 3 firms taking a lot of money out of RAF. And when the CEO dealt with that and had at some point had a press briefing, then there was also inconsistencies in terms of how we deal with that matter. But be that as it may, when it was reported to us, like you are saying, we didn't dispute it. We agreed that, yeah, these firms now no longer have to find expression because the 180 days issue is not there and they must not do it. And we all agreed that the public must come and claim on their own. We all agreed that RAF must have a drive that is to conscientize people how to claim, where to find RAF. They must avail offices closer to the people so that people do not have to fall victims of lawyers that go to them in hospitals the moment the accident happens. I think there is another syndicate that is operating in hospitals, doctors and nurses, because you will be laying in hospital after an accident, then you get approached by some lawyer that you didn't invite. So to cut that and that corruption, because the same lawyers do not even give the people their own money, which was another shortcoming which RAF was not monitoring. Now, we agreed that those things must happen and RAF must tackle those things. What I'm struggling to understand is then where did the problem start, or where do we come in? Because we are now going to be remote controlling the movements of RAF and all of that. As far as inflation of those people who must execute the task in terms of whatever media coverage, what do you call it, those campaigns and all of that, that's something else which has to be dealt with. But if how it comes to be an inquiry, I'm struggling to understand that. The other thing we all agree that it must be corrected, which the inquiry is not going to resolve if that is not corrected, is the issue of the legislation in RAF and how it allows people to steal money from RAF. That includes the medical aid insurance companies that take our own money. After taking our money, they still go take money from RAF to pay the same person. It's the matter of hospitals that claim a RAF, is the matter of the lawyers as well. So there was a list we asked from RAF in the last meeting, a meeting before the last one. That meeting, I think it was March, which was sent to you. And in that, we asked which are these hospitals and how much has been paid to them and why this space is not regulated, because the legislation must regulate. If their hospitals must claim, what are they claiming? Because Hospital A will claim for a tow 1 million. Hospital B will claim 100 rand for a toenail. And then my claim, True Lawyer 1, will be 1 million from RAF, but True Lawyer B, it will be 50,000 from RAF. So there has been that gray area as to how do we get different claims for same or rather similar accidents, but people get different claims of that. What's taking place now is the board and the CEO, as we have seen in the transport committee, transpiring there after our engagement. Unfortunately, myself and Skosana were not here. Then after our engagement, then transport committee takes over. Then there is a full-blown war between the CEO and the board. And that is informed by what the board did to the CEO, and the CEO fighting back for his life with the board and all of those things. That also, I don't know how we're going to get involved, because the executive ultimately must deal with the board, must deal with RAF. And yes, we can get in terms of utilizing the constitution and the legislation on how the things should be done. But what is it that we would want to address in a war? There's a turf war between the CEO and the board. That goes without saying. And it cannot be resolved by us in the inquiry. I feel that the executive is failing and is not doing its job. The executive must deal with its mandate, and the executive must deal with the issues of RAF. That must not be given down to Scopa, that Scopa deal with these people for us. People must do the dirty things. It must not be Scopa who's going to be doing the dirty. We are not scared of doing dirty work. We'll do the dirty work, we'll fire people, we'll inform the communities of who is stealing where. But the executive must rise to the occasion and act where it has to act, the way it has to. If the CEO has to take them to court, or the board must take the CEO to court, they must do it there. They must not use us, because we have a bigger community to attend to, and that community is waiting for us. Chairperson, I think that's it for me. Thank you.
Thank you very much, Honorable Member. And I'll come to you, Honorable Members, as well. But I do think that I also need to honor you with some direct responses. So one of my concerns with specifically the volume of work, and I'm repeating the point, is that we are not able to deal with the matters that, at least in terms of my own space. I really cannot tell people who bring pertinent information about financial losses and so on that, I'm sorry, we're dealing with other matters now. I can't in good conscience do that. The question is, how does the committee handle such a volume of issues in such a way that it's able to attend to some of the matters? As it happens, Honorable Member, one of the conversations I had last week was both with the finance minister and the mayor of the OR Tambo District Municipality, as an example. One of the things this committee has to do is that, to the extent there's going to be emergency aid that goes there, we must make sure that we work with the Auditor General to make sure it's not eaten. Because we've seen this problem with COVID. We can't do that if we're dealing with one institution coming here back and forth all the time. So that's the one. The second is, I appreciate that you've had other commitments also for Parliament outside. We actually seized with the matters of the very municipalities that you're talking about. And in fact, we're planning oversight. So we've already taken presentations from the AG, from the SIU. Next step is now how we deal with those municipalities themselves. So what I'm trying to say, Honorable Member, is that this is not an either or for me as chair. We are seized with those matters, and the members have been dealing with some of those issues as well. I do need to deal substantively with the issue of waste. In fact, firstly, with the issue of how the road accident, the kind of challenges the road accident fund has to deal with. They are not the only one. We had the compensation fund here. They identified the same kind of problem, exactly the same kind of problem as the RAF, in as far as how their financial statements are prepared. You know what? They are complying in the meantime. That's the point. That's the difference. There are other instances where an institution sits here because our first wife says they have not done work. Let me give you a very specific example. We had Eskom sitting here. Municipalities complete their financial statement. Their financial year ends in July. Eskom's financial year ends on the 31st of March. Eskom is not able to say what the impairment on municipal debt is going to be, because municipalities are in disarray, they can't complete their financial statements and so on. So painfully, they accept what the first wife is saying, even though they can do nothing about the lack of readiness of municipality A that owns Eskom 3-4 billion. And the Auditor General comes here, tells us Eskom can't get their financial statements ready on time. They take it on the chin. I then asked, and you will see, Honorable Member, and this is why these things are important. I then asked the Road Accident Fund, because you can also exonerate management, where on the basis of legal advice, they then took certain decisions. I then asked, please send the legal advice that you got. They say, we don't have it, it doesn't exist. So now you're asking, but on what basis do you go on and spend all of this money? So that's one. The second thing, Honorable Member, I think the administration of justice in South Africa is very important. We have the Legal Practice Council here tomorrow. In fact, to ask the very questions about law firms that rip off the rough, they're here tomorrow. So we're attending to that matter as well. But if you enroll a matter, the biggest court in South Africa is a Gauteng court. If you enroll a matter today, they will hear it in 2030 because of the Road Accident Fund. People, indigent and otherwise, need access to speedy justice. Nearly 60% of that backlog is caused by the Road Accident Fund. Now, they might not be paying law firms, but our second wife is investigating how the default judgments where the RAF is not there to defend them rack up to 4.7 billion at last count, which taxpayers must pay. Because had the RAF defended those matters, we would be paying less, which means we save on the lawyers, we also save on the claims. So all I'm trying to say, Honorable Member, is I hear you. However, the matters and the financial impact are actually really material. There are also service delivery issues if you consider the delivery of justice to various people to be important. We can't make people wait 5 years before their matter is heard in court. I'm also cognizant, finally, of the dispute between the Road Accident Fund and the board and the ministry and so on, and the tenure of the CEO. One of the things I love about what we are deciding today, I'm told the tenure of the chief executive ends in August sometime. That's not my problem. Whether the CEO continues or doesn't continue, that's not what this committee is concerned with here. Whoever has to account at an appropriate time must come and account. They must deal with the matters of whose contract is renewed and when. But there are clearly material issues that I think we need to deal with. My proposal, as I've said, which I will then ask the members if, and I think members have expressed their view, that we proceed with this so that we can leave the RAF alone for a year, if it must be, until they have to present their financial statement, because we've dealt with it. Then we can deal with the service delivery matters and so on. But I appreciate the comments, Honorable Member, because that's my difficulty as well with having to deal with an avalanche of emails on one institution when the committee oversees over 400. Even for the committee staff, it's a misallocation of their time. So we can't escape the problem, unfortunately. We end up being in it. My proposition is this, that we obviously asked for the assistance of the Auditor General in the preparations. They are clearly in the audit itself. So some issues might actually just be dealt with in the normal course, because all we get is an answer. We don't need to, to ask people any further, because the AG will present. I want to propose that we still not delve into the specifics of matters the SIU is dealing with, especially where conclusions have no. So in other words, we don't identify a person, bring them here, when the matter still needs to be concluded in as far as the SIU investigation is concerned. The only thing the SIU may assist us with is where there is a piece of information that would inform the committee properly, and then we can deal with it on that basis. But I don't suggest we run a parallel process to the SIU. Similarly with the police, I don't think we should ask them what investigation they've got going on and then we run a parallel investigation at the same time. Let us confine ourselves to oversight in respect of maladministration, in respect of financial mismanagement, financial impact on the Road Accident Fund, and good governance. The policy matters, I agree with Honorable Member. The Road Accident Fund is dealing with a liabilities problem not of its own making. And the Transport Portfolio Committee needs to speed up the process of changing legislation so that these matters can be resolved. So I am going to do this, and I will need guidance. I think the only person I heard saying maybe an inquiry is not needed is Honorable Mende. Do I understand that correctly? I don't want to misstate. Or do we have someone who says also, because I don't want to assume that we know how the committees voted. I really want to be specific so that we know what decisions we are taking here. Honorable Scosa.
No, Chair, the issue of inquiry, indeed, it caught me by surprise. By the way, I must make a disclaimer on that. But I think we should consider all the other avenues, because these inquiries as well takes time, Chair. You know, you might have a different opinion to say it will be completed within a short period of time. But from my experience of what I've seen, even when I'm still outside Parliament, inquiries is like commission of inquiries. You know, there's so many things. You've got the Zondo, so-called State Capture Commission, which took, I don't know for how long. There were deadlines, there was extended, there were issues. I'm just giving you an example. For me, sometimes there is a waste of time. So for me, if there's another alternative, the better. Thank you.
So I ran the risk of kind of messing up my own order. So Honorable Madlala, I'll give you a chance. Honorable Atkinson I put up his hand a long time ago, but please continue, then I'll come to Honorable
Thank you,
Atkinson.
Chair. I want to understand this inquiry thing. I think maybe I did not capture it very well earlier. My understanding is that we're saying SIU must get an expanded proclamation because there are issues that keep popping up and we are not a right platform to ventilate all of these matters. And we're saying HSA, go and look into others. So it's not like there's going to be I might not understand that there's going to be a separate inquiry where there is a chair of an inquiry. And we're just saying the existing institutions, because matters keep on propping up and we can't ventilate them. We ask them to say, within your area of expertise in any way, but just go and look further into these issues, and these are the terms of references. I want to understand if there's an inquiry or it's what I understand to be saying. Thank you.
Thank you, Honorable Madlala. Let me explain. So we're going to have both because the two are not the same thing, right? So what will happen is that there will be two things that happen in the background. The first is that we compile all the information received so far, right? Whether it is submissions of the RAF, the ministry, and so on, plus whistleblower accounts and all of these kind of things, plus the questions and requests for documents that I have made and that we now will make. We then compile all of that and synthesize it with the staff of the committee, so that each of the members has a complete file instead of calling up the RAF each time to come and account. Okay, so we deal with that. And we then, on the basis of that information, and I've at a high level shared some of that, we then set aside a time where the same members of committee deal with everything, right? Part of what comes out of that is that the committee might conclude that we need a special audit, for instance, as it has done before. So outside of the normal audit, the Auditor General needs to give us a special audit on certain matters. But we need to inquire properly first, so that it's an informed ask. So that is the first thing. The second thing is we might then say, for an example, and there is information already, and that's what I'm proposing. There's information that is obvious. In other words, someone says, it's me who was involved. I did the following. The SIU is already investigating. Pass that on. Some of it does not fall within the scope of the current investigation. In those instances where the whistleblowing is clear and comprehensive, we simply ask the SIU to expand the scope of its investigation because the information is there. They might deal with it, right? The third is that out of these inquiries, we might decide that actually the ministry has been failing. and we need to hold the minister accountable and the deputy minister and so on. But we've had them here to answer the question. So it's not an either or, Honorable Madlala. It's to say, to curtail these 20 meetings with the RAF, let's pull the information together, have one. Now, that might mean we just allocate a week to do that. And we deal with it and we're done. What we have to do clearly, both in terms of the terms of reference and the specific matters we deal with, we don't go over what the committee should deal with. So in other words, we're not going to conduct forensic investigations here. And neither should we. We deal with matters that pertain to oversight so that we can then hold the executive accountable. So I hope that makes things clear. Otherwise, we're going to have them here 4 or 5 times a year, and I don't think that's appropriate. As Honorable Member said, it misdirects our time. So that's what I'm proposing. Anything that comes after, it will then have to come in the normal course. Sorry, we can't keep dealing with the RAF the whole year. Thank you. Honorable Atkinson.
Thank you very much, Chair. Chair, I think in my opening comments, I made the point that the likelihood is that this could well dwarf anything that that Scope has dealt with as far as money that has been lost or misappropriated. So I think it's incredibly important that we actually do a proper inquiry into what's been going on at the Road Accident Fund. And I know, we get the SIU and we get the NPA here, and people complain because we don't seem to be getting the correct amount of prosecutions, and people feel that everyone's getting away with corruption and everything. And I think if we kind of make the comment, oh, there's so much else out there that we must be doing that we can't sort of spend too much time on RAF, that there's a possibility of us doing exactly what the South African public doesn't want. The South African public actually wants to start seeing results from investigations into maladministration and corruption. And I think this is a prime example. We've seen it. There's so much here about where the committee has been lied to, where information that we've been given doesn't accord with what we're getting from whistleblowers. The fact that the organization has been continuing on its own merry way, in effect contravening the law, and quite possibly run by a CEO who's actually not even legally appointed to his position. So there's a hell of a lot wrong there that we need to look at. And I think the issue is this committee's success will be measured as to the success that we have on bringing people to account. Unfortunately, if we have to deal with all the corruption in South Africa, we would probably need 25 scopers. We'd need 25 of these committees to deal properly with everything. So in a sense, the committee also has to make decisions as to what's the most relevant, and actually look at the kind of amounts of money involved. And I do believe in this, that as much as Mr. Letswalo tells us he saved the country money, I think that's yet another lie that will be shown when, as Honourable Nontenja said, we have a proper forensic audit into this whole thing, and we understand the liability that he's actually incurred for the Republic of South Africa and for our taxpayers as well. So I'm very much in favour of a proper investigation into this, and I'm very much in favour of this committee getting to the bottom of it and getting consequences for people's bad actions. Thank you.
Honourable Neil May and then Honourable Skosan.
No, thank you, Chair. And Chair, I think Parliament has a constitutional duty to hold public entities to account. And the RAF is entrusted with compensating vulnerable road users, a matter of constitutional justice, human dignity and public trust. I think it's very important that those are the key words that we need to remember. This is not just any other entity. I think a committee inquiry is not just warranted, it is obligatory in this case, given the scale and severity of the governance and operational failures. I think it is absolutely, out of all the entities and all the presentations that we've had, I would say this would be number one. And I think we need to focus on that. And at least we owe it to the public and the citizens out there. Thank you.
Thank you. Honourable Skosan.
Yeah, no, thanks, Chair. Yeah, just to strengthen your point and the points that were also raised by Honorable Atkinson and Honorable Neil May, I think the advantage of this process, Honorable Madlala, is to give an opportunity to everybody all at once. Because immediately the public is made aware that we are going to do this inquiry, and everybody who's got an information, they will be able to come forward and says, I need an opportunity, I want to present this. Then we deal with all that information all at once. You see, so that we run away from the point where this week we are calling RAF because there's a whistleblower who have submitted a certain information, so we want clarity from them. 2 months later, somebody has written to the committee, then we say, hey, let's call the RAF to come and respond. So we are avoiding to keep on calling them now and again. I think that will save time on our side, but it also save time on their side so that you will also have more time to focus on their responsibility as an entity. So once we publicize this thing, every person or every entity that is having an information that can assist in the inquiry will be able to come forward. And once we're done, we're able to focus on other things. Because if we do it by piecemeal, I think it kind of disorganizes us, and it also disorganizes them as an institution that now time and again we have to call them. They must fly from wherever they are and come to Cape Town and respond to issues. So let's get all the issues at once, consolidate them, put some dates, and then get every person that we think is important to share any information that we think that can assist us. And obviously, like we have indicated, if there's an information that require SIU, we will be able then to take that information and refer to SIU so that they can consider having a proclamation to extend their scope of investigation. So that's the advantage of having the process. But as much as we are doing RAF alone, it doesn't mean that it is the only institution. Like colleagues have indicated, there are quite a number of institutions that have challenges, and government departments, municipalities, etc. But now to do this, it will send a strong message to other entities, to other departments, and to municipalities that if they are found to be on the wrong, Scopa can take the route of having this kind of inquiry. So it's just one, but it will serve a strong message, and it will serve as an example. So I think it's a very important exercise that we need to take. Thank you very much.
All right, honorable members, can I then, on the basis of this discussion, conclude that we are going to have an inquiry. We will send in writing to the members the proposed terms of reference. The members have an opportunity to make comment on that. On the 1st of July, we will then discuss and finalize them properly in this way. What is important is that, and this is where the public may be dissatisfied, we have to stick within the ambit of the mandate of this committee. Some things may be for the Transport Portfolio Committee to deal with, and we just need, and I will get the advice of the Parliament Legal Services to make sure that both in terms of the rules and the Constitution, we stick within what is in our ambit. The maladministration, financial mismanagement, waste, etc., all of those things. Not everything, we're not conducting an audit, but instances where the committee has had oversight issue before and continues to do so, and to the extent that we need to be sure what actions are being taken to address them, then we will sit and invite those people here. We will testify under oath, but we will keep the members informed always. So the terms of reference will not be concluded without the committee formally adopting those terms of reference to do so. I am looking at the time. We haven't had a break, one, and secondly, we're supposed to finish at 1. So are the members happy that we just find time to consider the reports, because we're now at 12 o'clock, and that we can find the time, right? So we'll find in the next week time for us to consider properly the reports that we're supposed to deal with today. Can we adjourn, members, on that basis? Thank you very much.